Yeah, good morning.
Coming before you is Michaela
Every
Fed.
day in the USA, someone walks into court hoping their whole life won't change in a single moment. Today, 22-year-old Michaela Fed stands terrified, facing a felony, begging for probation, anything to avoid carrying that label forever. But the law is unforgiving and her options are closing fast.
Is Michaela Fed in two cases, 2399 and 23100. In this case, Your Honor, we've negotiated to an impasse. At this point, there's certain concessions Ms. Fed needs or is requiring, and those concessions.
As prosecutors and defense argue, Michaela's voice breaks. She pleads for a chance, a program, even 6 years of probation. But the judge can't change the law. The offer on the table includes community control, curfew, an ankle monitor, and still makes her a convicted felon. She's desperate, confused, and running out of time.
Concessions the state's not willing to make. So as I explained to her, that's what a jury's for. So we'll just set this on a jury trial, Your Honor.
Okay, what we'll do.
I've got February. I've already got at least one, maybe two. We can do it in
I'm
April.
thinking April.
Okay.
So what we'll do. You got a question, Ms. Fed?
When the deal is read aloud, Michaela freezes. She doesn't want it. The judge stops everything because if it isn't voluntary, it can't happen. For the first time, someone tells her the truth. She still has a choice. She can take the risk, face a jury, and possibly walk away without a felony.
Fed?
Yes, sir. There is, it's like, could I do like 5 years probation and anything to let me be like the PTI so I don't end up a felon? I'm 22 and that's my biggest thing. Just, I will do probation for like, it doesn't matter how long, just to end up not being a felon. I don't want a title on me the rest of my life.
I don't get involved with plea negotiations. That's between
Shaken but determined, Michaela chooses trial. The plea is gone, the ankle monitor gone, and the future uncertain. Now the state must decide which case to take forward. One choice could haunt her for life, but the other might be her only shot at freedom. Court ends, but her fight has just begun.
That's between your attorney and the state, and a PTI, that's something completely up to the state attorney's office, whether or not they want to allow you into their intervention program. I don't get involved in that at all. If you want me to sentence you, what I'm looking at, I'll listen to your attorney, I'll listen to the state, and
the problem with that, Your Honor, is obviously if you sentence her, it will be to a plea of fleeing and attempting to elude. That is by
degree?
statute.
Is that a second degree?
It is, but by statute, you have to adjudicate her.
Yeah.
That's what I told her. It would be against the law for you not to adjudicate her as a felony.
I don't know anything about you, but the law is the law, and if the law tells me that I have to adjudicate you guilty based on the charges, I'll have to adjudicate you guilty. I can't make any exceptions not to apply the law.
So what about the no contact? We have been together the last 5 years. We work as a team every day.
That's with her. That's with her co-defendant. And again, as far as I know, the state's not moving from that.
Every day in the same house.
They have children.
Taking care of our 1 and 2 year old children.
We can change that to peaceful contact like we did the grandmother. That wasn't one of the things that was asked, I don't think, but.
It was definitely, yeah.
Okay, so it would be peaceful
Judge,
contact.
if I could put something on the record.
Yes.
As well. Judge, Mr. Wilson has worked very hard on this case. He's talked to me about this case probably more than any other case he's had, Your Honor. So I wanted to be sure that was on the record. There's been a lot of concessions given, and we got to the point where no more. So I'll give Ms. Fed a little time this morning if she wants to speak to Mr. Wilson, but the plea offer as it stands is it, or it's being taken off the table today.
So did I hear you right that you were willing to do a peaceful contact with Mr. Clemens? That may tilt us in the right direction, Your Honor. Okay. Let me talk with Ms. Ms. Fed, and maybe we can resolve this today after all.
Yeah, Ms. Fed, I'm looking at the information. That's a second-degree felony. If you
there's
want,
no way I'm going to get out of this any type of way without a felony.
No. What I'm saying is, Mr. Wilson and Ms. Smith can negotiate a resolution. You can go to trial and let a jury decide whether or not you committed these offenses, or the state can prove that you committed these offenses. And you ask the question, can I sentence you? I'm looking at the information. If I sentence you, it's a second-degree felony, and I have to adjudicate you guilty. Not saying that I have to send you to prison. I'm not sure what your score sheet is, but
felony title regardless.
But
there's no way.
If I sentence you based on this, you're gonna be a convicted felon.
Well, either way, it seems like I'm gonna be a convicted felon.
I don't know what the plea offer is.
That's what I'm saying. I'm trying to see if I can do like 5 years of PTI, where you do, so don't end up a felon.
I can't say yay and nay on the PTI. That's up to the state.
That's not the offer they've made. That's what I was trying to tell you. The judge can't do that. So I've changed this to peaceful contact with both these people. And it's otherwise what we discussed. If you don't want to do that, we can put you on a trial document.
She won't even let me do 6 years of probation to not be a felon anymore.
Ma'am, she won't let you do anything else. That's it. She just told me you got,
Statute. My hands are tied.
There's nothing you can do.
That's it.
No amount of PTI. So I will not have this felony title on me for the rest of my
You
life.
need to talk to your attorney, but you do not qualify for PTI. That's the offer.
And it's gonna be worse if I go to trial.
it's, if you're, well, you can always be found not, man, let's step, there's people trying to work.
Ready, Mr. Peters?
I'm ready, Your Honor. I got Mr. Willie Hill.
And back before you was Michaela Fed, again, in case numbers 2399 and 23100. In 2399, Ms. Fed will be pleading, it'll be no contest, but she will be, as we discussed, adjudicated guilty. She's pleading to count 1, the fleeing and eluding, which is a second-degree felony. Count 2, the resisting without violence, that will be consolidated. Count 3, the possession of paraphernalia, she'll be pleading to that case as well. Then in 23100, it was originally charged as a felony battery over 65. She'll be pleading to the misdemeanor battery. So that is now a first-degree misdemeanor. She should do 2 years of community, again, she's adjudicated. She should do 2 years of community control with curfew and ankle monitor, followed by 2 years of regular probation.
I didn't get the ankle monitor part. I'm so sorry.
Oh, no, you're fine.
Come
This
on,
is-
who's gonna hire me?
This is your
Being a
life.
felon with ankle monitor.
Yeah, can we get a trial date?
I want to, I need some more time to talk. You want to come back?
I was told that she is now probably a minute over the deadline she had to accept this offer.
Ankle monitor for how many?
Judge, at this time, the state withdraws that plea offer that was just read out by Mr. Wilson and requests a trial date.
I told you what you were gonna do.
Ms. Fed, do you need some time to talk to Mr. Wilson? The state looks like they want to pull this off the table. You can accept the state's offer. These are your options, Ms. Fed.
Can I ask you personally, which one do you
Can-
think is gonna be worse?
Ma'am,
Do you think it's gonna end up way
The
worse for
judge
me?
cannot
if I
give you
go to
I
legal
don't-
advice.
I can't
That's
predict the-
also against the law.
I can't predict the future. I'm not sure what a jury's going to do. I don't know any,
I need to go to law school.
Ms. Fed,
At this
listen, ma'am.
point.
Ms. Fed, listen. I don't know anything about the facts of your case other than what I've read in the complaint affidavit. So other than what the police said, that's the only thing I know. You have a good lawyer. He will if you go to trial, he will represent you. He's done it hundreds of times before. He knows exactly what he's doing. I don't know what a jury would do. That's one option. The second option is to accept the state's offer. What will happen, I'll ask you some questions to verify this is exactly what you want to do, that you're doing so willingly, no one's twisting your arm, that you know what you're doing, and I'll accept that. The third option is you can reject the state's offer, say you don't want to go to trial, and you can say, Judge Collier, sentence me. Again, I don't know anything about your background. I don't know anything about you. I can tell you with the information that's charged, you have a second-degree felony, and the law in the state of Florida is I cannot withhold adjudication on a second-degree felony. So I will adjudicate you guilty. You'll be a convicted felon. The other conditions, whether or not I send you to prison or probation, I don't know. I'll tell you, the last time someone appeared before me with a high-speed reckless fleeing or attempting to elude, I'll just say this, he's not home, and he ain't coming home for maybe another 6 years or so. Not to say that's going to happen to you. I don't know.
So it's serious. And it's a very serious matter.
It is very serious.
Okay. A second.
Can I proceed? So it's the 2 years community control with curfew and ankle monitor. Two,
Don't get mad at me, I'm sorry. Come on, ankle monitor.
There is nothing else. And everyone in this courtroom is waiting on us. We're acting like a couple of fools up here.
No, you're fine.
Can we get rid of the ankle monitor now? What is the ankle monitor gonna help me?
Miss Fed, don't talk to me anymore. You're represented by counsel.
This is inappropriate.
But y'all want to come back? We'll leave that open to tomorrow. No? Okay.
Did you-
I'll take it, but I just feel like come on, what is the ankle monitor gonna do?
How, I can't get involved in plea negotiations. That's Ms. Smith. Ms. Fed is asking that you remove the ankle monitor. The answer, the state said no.
That's right.
Okay, it's on the record. No.
Okay. I wear the ankle monitor. Cute, Dura.
Court costs and fines, restitution that says to be determined. There was no damage that I know of, but there could be investigative costs. I don't know. $100 of public service, cost of supervision, drug and alcohol evaluation and counseling is recommended, 0 tolerance. DMV may apply additional penalties, time served on the misdemeanors, DNA sample, testify truthfully against Ricardo Clemens, no, only peaceful contact with Deborah Williams and Ricardo Clemens. Count 2 is resisting an officer without violence is consolidated. I believe I already read that into the record. Is that your understanding of the plea, Madam Prosecutor?
It is.
I'll try to get through this. Ms. Fed, you raise your right hand for me.
I'll pass it up.
Except, what am I supposed to say?
solemnly swear affirm the testify you shall give me the truth, the whole truth, and nothing but the truth, so help me God.
Ms. Fed, is this what you want to do, ma'am?
No,
Okay.
but it's what I gotta do.
No, it's not what you got to do. If this is not what you want to do, I can't accept your plea.
I just don't understand why I'm gonna be a felon. I'm gonna be a felon, obviously. So what does the anger monitor do?
That's not the case. You can always go to a jury trial and I can tell you, listen, I've been in trials and I thought a jury's gonna come back with a guilty verdict. They come back not guilty. Been in trials that I think they're gonna come back not guilty. They come back guilty. You never know.
So you're telling me I could take it to trial and still end up not being a felon? There's a chance that I could get out of this without being a
You
felon.
can go to trial. The state will have the burden to prove the case against you. Mr. Wilson will stand up, cross-examine.
I'm in trial.
Okay.
I'm in trial.
Okay, I think based on what's happened today, and Ms. Fed is basically telling me she doesn't even want to accept this. I don't think it'll be knowing, intelligent, and voluntarily entered into, even if I
understand,
accepted
Your
it.
Honor. That's kind of what I
I
thought
don't
when we
like it.
stood up.
So what we're gonna do,
I don't make it work for myself.
but we're not saying you're gonna make it worse for yourself. That's a right that you have. You never know what's gonna happen. So what we're gonna do,
You can destroy
Um,
that.
Ms. Fed, we're gonna place you on the April trial docket. That's 4/15, and we're gonna come back. Y'all gonna come back in March 8th.
Judge, there's, the pleas off the table. There's no need, Judge. We can just put her on the April trial management and April trial.
This
I don't have an April trial management. That's all.
is March.
Okay, that'll be fine.
March 8th.
And I was gonna start putting the trial managements the month before trial to give you an opportunity. Because usually we fill up that trial docket to give the state and the defense a chance to see exactly what's gonna go to trial. So we'll we'll place you on the 4/15 trial docket. We'll bring you back March 8th at 9:30 for trial management, okay? All right, Ms. Fed, just make sure you stay in contact with Mr. Wilson. I know this offer may not be what you want. He's a good attorney. Stay in contact with him because you're gonna be in trial.
Come on. Because then if I take it to trial, like the battery, every charge will be on trial, right?
That's correct. You'll be facing
So I
everything. There'll be no amendments.
But we wouldn't try them both together, so,
But-
the state would choose, but right now, you're charged with aggravated battery on a person older than 65.
Exactly, and that's what's scaring
And
me.
the state will basically decide whether or not to take that to trial or take the fleeing or attempting to elude to trial, and we'll talk about that in March.
So y'all will decide to take it to trial?
No, you have two different cases. In the state, we're not gonna try both cases during the same week. So the state will either say, Judge Collier, we're gonna take this case to trial, which is the fleeing or attempting to elude, or we're gonna take the aggravated battery to trial. So they'll pick and choose which one they're gonna take to trial in April.
Okay.
And we'll try that case and we'll see what happens. And then you'll still have another case that's out there. And depending on what happened in this case, the other one can be resolved or we'll go to trial on the other case in the future.
All right, let's do it.
Do,
Try.
try? Okay, then you're free to go.
Thank you.
Thank you, ma'am.
Mr. Rogers?